There are many individuals who are suffering right now with a massive amount of credit debt, credit cards, loans, car loans, mortgages, and the like. I will not take time to explain this debt-based system in this video, but without credit, our system would collapse because the way it's constructed, it needs credit in order to keep going. Many individuals are trapped making payments on their credit cards. They go out, they earn, gain, and pursue after a living, only to turn this over to the bank or to their creditors to pay for their credit cards, their loans, and their mortgages. Again, these creditors have not put up any consideration into these loans, but are stealing from individuals their energy through making these debt payments. So when the bank apparently lent you the money, we understand that they don't put up any consideration for these loans. But when it comes time for you to pay off these loans, you are actually placing real value and real consideration into this relationship. Why? Because the only way for you to make money is for you to go out there and to earn it, to gain it, and to pursue after it through work. And then once you earn it and gain it through your energy, through working, you have to turn it over back to these individuals who lent you this debt, who lent you these loans. However, the ones who lent you the loans, the bank and the mortgages, they're creating these amounts out of thin air. They're creating these accounts through computer strokes on a keyboard. That's all they're doing. They have no consideration into these loans. But anyways, individuals, families all across this land are losing all or are in jeopardy of losing all because they are trapped in this debt-based system. The economy is not doing well, and the abundance of jobs that once were have vanished. Example, the oil industry in Canada. With the recent downturn in the price of oil, a lot of industries that are associated with oil are turning downward, losing jobs, laying off individuals. Many who can no longer to afford to pay their debt are being taken to court by lawyers, and these lawyers are securing commercial judgments against these people, the inhabitants, and causing many to lose their homes from the judgments of the courts. So I want to speak about a mechanism that is available for a man or woman who is at risk of losing their home, their possession, the security of their person to such a judgment. What usually happens is that the lawyers who represent the bank secure a judgment against you, and then will try to make you leave your home, leave your possessions. The judgment that they are making against you here in Canada is being done under a common law mechanism of law. And this is an important fact to remember and to bring forth and to commit to memory. Now, talking about mortgages and hypothecs, to show you the difference. In civil law, okay, it differs from common law mortgages, particularly that it confers the hypothecary creditor no immediate right of possession of the property, but only a right against the proceeds of sale of the property after enforcement of the right in the judicial proceedings. And the common law mortgage, on the other hand, gives an immediate right of property to the mortgagee, who can take possession of the property by a simple notice without the necessity of taking suit, as well as the right of foreclosure at law. In Canada, the hypothec, the mortgage that is being used in our provinces, is a common law mortgage. And within the terms and conditions of the mortgage, you give them the right to take possession of the property if you default on your payments. If you read your contract that you signed with them, within it you will see that you declared that if you default on your payment, that they can take possession of the property by a simple notice, or that they can continue against you with a foreclosure in court at law. Now, the civil hypothec differs from the common law mortgage, particularly that it confers on the hypothecary creditor no immediate right to possession of the property, but only a right against the proceeds of sale of the property, after enforcement of the right in judicial proceedings. That's not what happens here. When you go through judicial proceedings or when you default on your mortgage payment, the bank or the mortgagee wants to come right away, take possession of your property, change the locks, and kick you out of the property in order to sell it, in order to recover their apparent loss, which is a lie before the courts anyways, because in the original contract, they never placed any consideration They never place any real value up for that mortgage. But the common law mortgage, on the other hand, gives an immediate right of property to the mortgagee, who can take possession of the property by a simple notice without the necessity of taking suit, as well as the right of foreclosure in law. So if you default, they can send you a notice and say, pay up what you owe us, or we're taking possession of your property. You agreed to this in your terms of your contract with us. If your mortgage is at common law, then common law it is. If your mortgager, the bank, which is a Canadian corporation of Her Majesty, tries to exercise the common law right to take possession of the property, then you would need to use your common law rights also. Here in Canada, our mortgages are made through common law, and it is this mechanism that they will use to remove you from your home and take possession of your property to sell it. They will send a bailiff to your house to change the locks and so forth. They even go so far as to ask the police to come and escort you from the property. So you're late, you haven't paid your mortgage for 3 months, your lender contacts you and says, pay the arrears, pay what you owe us, or else we're going to take possession of the property. We're going to take possession based upon the terms and conditions that are in this contract. Or the judge produces a judgment against you that says the bank has the right to remove you and to take possession of the property in order to sell it and recover the money. It is such a disgusting game that is being played on men and women. The bank sends their lawyer to the courthouse seeking an administrative judgment against you under common law. They show the court clerk the contract between you and the bank stating that if you don't pay, that you gave them the right to take back the property. Then they show the court clerk that you are late paying, that you haven't made your payments. Now, based upon this information, the court clerk issues an administrative judgment against you, and you will lose your home. Even if you intercept what is going on and open your own court case, if you do not know what you are doing, they will still produce a judgment to take your home away from you. The judge, the court clerk, who produces this order has just violated your fundamental rights and freedoms, and through this judgment has taken away your security of the person, as indicated in Section 7 of the Constitution Act of 1982. They just removed one of your inalienable rights. You, as a man or a woman, as a family, you have the right to a home. If you don't have a home, if you're living on the street, you risk dying. You can freeze because of the elements. You can starve because you have no food. You can get sick because of the diseases, or you can even be subject to criminal activity. And part of the security of your person is your right to have a home. Now, they violated this right from the beginning here in Canada against you by forcing you to take a mortgage and qualifying for a home by having a good credit score and a good job. This was never the qualifications for you to exercise the security of your person. You have a fundamental right to be free from fear and want, to have shelter to live under that is not stolen from you because you cannot give banknotes to them. Now, in Russia, we see that just the opposite. The government must respect and even pay you for the fundamental right to a home. So while here in Canada, the Bar Association, the lawyers are playing a game against us and are limiting and abridging our inalienable fundamental rights and freedoms, in Russia, in their constitution, they state that they have to protect the right to have a home. You see, in Article 40, it says everyone shall have the right to a home. And the everyone here is talking about a human being. No one may be arbitrarily deprived of his or her home. So the human being, you have the right to a home, and no one can take that home away from you. The bodies of the state authority and local self-government shall encourage housing construction and create conditions for exercising the right to a home. Low-income people, okay, you see that? Not all people. If you're a people of the state, if you've got a good income, if you have a rich income, you don't qualify. But low-income people, so you know which people they're talking about here. They're talking about the incorporated one. They're talking about the one that's part of the corporation and its officer. But low-income people and other persons mentioned in law. While the other persons mentioned in law is the one that comes out here, the everyone, the human being, the man or the woman. And other persons mentioned in law and in need of a home shall receive it free or for reasonable payment from the state, municipal, and other housing stocks. So, in Russia, if you invoke your right as a man or a woman, your inalienable right to have a home, you place the responsibility upon them to actually issue a payment for that home for you to preserve your right. Yet in Canada, these judges are making judgments against you, stripping you of your fundamental right, stripping you of your constitutional right. The judge makes the order against you, and this order that he makes, or she, is violating your right to have a home for you and your family. If you cannot pay this fake debt that the bank created, then the government should take care of it. Why? The bank is part of the government body. Oh, wait, the bank already has the right to do this for you. You gave them this right when you opened up an account with them. And if you used a mortgage broker or company, I suggest you verify your contract that you signed. You will find a similar clause to the one the bank has. They claim the right in the terms and conditions of the contract to set off the balances that you may owe the bank in any matter they consider. When they decide and choose to set off these balances, they are not required to give you any notice. Now here's the terms and conditions directly from the bank's contract. Set off debts against your accounts. We can apply a positive credit balance in any of your accounts with us against any debt, obligation, or liability you may owe to us. We can set off these balances in any manner we consider necessary, unless we have specifically agreed not to do so, and we are not required to first give you any notice. So the provision is there to set off the debt if you become delinquent. They already have the provision, and if you check your mortgage contract, you're going to see the same situation going on. Again, the lawyers secure a judgment against you. This judgment is breaching your inalienable right that is guaranteed in the Constitution. So what does an individual need to do? You need to challenge that order of the judge. And I do not mean to go to an appeal, the order, in an appeal court. You can appeal it also if you want to, but I am talking about once all is said and done in their commercial court and they still secure this judgment against you, then you need to challenge it. Launch a constitutional challenge against the order of the judge, claiming that it violates Section 7 and 26 of the Charter and violates your right to the security of your person, your adequate living. I am using Manitoba enactment as an example, but it is the same in all the provinces across Canada. Now, Constitutional Questions Act in Manitoba. Notice to the Attorney General is required. Where in a cause, matter, or other proceeding, the constitutional validity or constitutional applicability of any law is challenged, or an application is made for a remedy against this law, the law shall not be held invalid, inapplicable, or inoperable, and the remedy shall not be granted until we notify the Attorney General and take a few other steps. So, we are challenging the law, claiming that there is a law that violated our inalienable rights. Some may say at this point, law, John, what are you talking about? You're talking about an order of the court. Why are you talking about law here? Well, law, when you are launching a constitutional challenge, is defined as the following. Again, Constitutional Questions Act in Manitoba, definitions. Law in this section, when you're launching a constitutional challenge, you see that, section 7.1, 7.2. In this section, law includes an act of Parliament of Canada or of the legislator, and includes a regulation made pursuant to any such act. So, law, when you talk about a constitutional challenge, it's an act of Parliament or an act of the legislator. We see that when and only when we are launching a constitutional challenge, law means any act of Parliament or legislator and any regulation made pursuant to this act. Well, what is an act of Parliament or of legislator? When we look into the Interpretation Act, we will find the answer. In the Interpretation Act of Manitoba, definition. Act means the act of a legislator or part of an act. Regulation means a regulation as defined in the Statutes and Regulations Act or part of such a regulation, and an act of the legislator means an order, rule, bylaw, resolution, form, or tariff of cost or fees made in the execution of a power given by or under an act or part of such an order, rule, bylaw, resolution, form, or tariff, or cost or fees. An order is also considered law. The order that you received from the court to leave your home is now law. They will try to force you to obey this law with their agents. They will come and say, you have to go now. You have to leave your house. We have a judgment, and it's the law. Yes, you're darn right, it is the law. And the order, this law, is violating my constitutionally protected rights. You can open up a challenge against them to have your remedy so you don't lose your home. So when they're talking about in the constitutional challenge, when they're talking about what you can do, you have the right to challenge any law. And then when you define what law is, law becomes an order. And the judge, he's making an order because he has power that's given to him by an enactment, by the Federal Court Act, by the Queen's Bench Act, depending what province you're in, depending what court you attend. There's an enactment or a regulation that's controlling the position of judgeship, that's controlling his office. And when he gives an order based upon the enactments or the regulations. He says this enactment, this regulation gives me power to produce this order. However, when you're challenging and launching a challenge, law is an order. So you have a right to challenge his order. And if he's telling you in his order that you must vacate your property, that you must vacate your home, what has he done? He's broken your constitutional right. He's limited and he's abridged your inalienable rights, your fundamental rights and freedoms, your absolute rights through an order. And he does not have the right to do this. And if you challenge, you can have a remedy. So once again, the judge produces an order against you. This order is given pursuant to an enactment that grants him the right to do this, that he sits on a bench. This order becomes law now, and they try and enforce this law against you. And the law that they're trying to enforce against you says you must leave your home. You must leave your property and go on the street. That is a fundamental violation of your natural rights and freedoms. It's against the principles of justice. It's against their obligations. You have the right to launch a challenge against what they are doing to you. You have a right to launch a challenge in this matter in order to have your fundamental right and freedom respected. There is a certain situation, there is a certain way to do this, and if you want to know more about doing this, you can contact me at EternallyAware@yahoo.com, and I will inform you what is required and what is needed.